Hi, this is Alan Gassman, and we welcome you to What You Need to Know About Bankruptcy, Part 2, Pre-Bankruptcy Considerations. If you did not see Part 1, you're fine, because Mike is going to do a great job today explaining a lot of very interesting and very important bankruptcy concepts. You will want to eventually see Part 1 with Al Gomez, but for today, you are absolutely fine. And I welcome you, Mike. Thank you very much for being here. I have Mike's biography for you here as the second page, which you're looking at. Mike is a very, very well-qualified bankruptcy lawyer, as is his partner, Al Gomez. Mike has been practicing in this area since 1988, and he's got the scars and experience and some remarkable victories to prove it. He's always a fascinating guy to listen to, and it's always a pleasure working with him on client matters. Please join us in Sarasota with Jerry Hesh on October 17. We're going to be talking about charitable planning, asset protection for businesses, and of course a cocktail hour. And then please consider attending the Notre Dame Tax Institute. Wednesday, October 25th, I'm going to talk about what every estate planner needs to know about federal bankruptcy law. Guess where I'm going to get my materials from? And then we have a beautiful 2-track series at the Notre Dame Institute. If you've never been to it, it's the best 2-day tax institute, if not the best tax institute you could ever see. Jerry Hesh designs a lot of these programs, a lot of these presentations, and he actually reads and fine-tunes the outline. Notre Dame University is a beautiful place. So Mike, I welcome you again, and we're off to the races.
Okay, welcome to part 2 of our webinar. We had some questions from last time, from part 1, about one question related to the discussion that inheritances can be considered property of the estate if they are received post-petition within 180 days of filing of bankruptcy. Are there any other exceptions that apply to post-petition earnings? And while they're not in the code as the reference to inheritance is, you can have a situation where someone's entitled to some earnings or something in the nature of a commission, where, for example, all of the commissioned work had been done. For example, a real estate agent that listed the property and entered into a contract, and then they file bankruptcy the day before the sale occurs. If that kind of thing happens, and then all the work was done pre-petition, and the only thing that was left to do was the payment of the commission, you can rest assured that the trustee would jump in and kind of try to intercept that. So that's certainly an exception there. There was a question about, does the automatic stay terminate when property of the estate is no longer part of the estate? And that question's yes. It's kind of normal that if property was no longer property of the estate, it wouldn't be protected by the bankruptcy. And does that include property that's abandoned? Yes, I think it could, but abandonment is a term of art in the bankruptcy code, so there would have to be an actual notice of abandonment, given notice to the creditors with an opportunity to object. Abandonment doesn't happen automatically except when a bankruptcy case is closed. Generally, any property that was scheduled is then abandoned. Of course, when a bankruptcy case is closed, there's no longer a bankruptcy estate. Then there was a question about what might happen at a 341 meeting. One of the standard questions that's asked is, have you listed all of your creditors in your schedules? And then the question was, how would it be possible to not name or list a creditor? Well, surprisingly, or maybe not surprisingly, debtors do that all the time. They get it in their head that they're only going to bankrupt certain people. They don't want to bankrupt their friend or their brother or their neighbor or whoever. They don't want to bankrupt their car. But the fact of the matter is, bankruptcy covers all of your debts and all of your assets, and you're obligated to list all of your debts and all of your assets. And that's why there's kind of two standard questions get asked at a 341 meeting, which is, have you listed all of your creditors and have you listed all your assets, and you're obligated to list both. Another question was, should lawyers who receive a bankruptcy notice from a client who owes them money, should the lawyer do something to challenge that bankruptcy? Well, you're no different than any other creditor, and so I guess what I normally tell clients is you've got to apply that standard cost-benefit analysis to determine whether it's worth spending time and effort to challenge the bankruptcy. The good news is, as a lawyer, you have a free lawyer, but as we all know, you're spending your own time, and so that's time that you could be spending doing other things, whether they're hourly collectible things or off having fun. But I think if you're a lawyer and you get a bankruptcy notice and you're owed an amount of money that you're not happy about not getting, you should look at the bankruptcy pleadings that get filed, the schedules, see if the client has listed all of its assets from your perspective. As the client's lawyer, you may have interesting information in your files. The client may have provided you with a tax return or a financial statement or something from his divorce case, or a variety of things that wouldn't be readily available to another creditor that wasn't the debtor's lawyer. So you want to look at whether they listed everything and whether they've claimed exemptions, and are there any objections to those exemptions that could occur. If they haven't been honest in their bankruptcy schedules by not listing all of their assets, then that would subject them to an adversary proceeding to object to their discharge under Section 727, and then they wouldn't get a discharge of any of their debts, including the debt that they owe to you as their lawyer. A sub-question on that point was, can attorney-client privileged information be used by the lawyer? Well, you might not be able to go public with it unless there's been a waiver of the privilege, which we'll talk about a little bit later. But obviously, if there's something in your head that you know about, the client told you in a confidential way, I have money hidden in a foreign country, while you can't disclose that communication, there's nothing to stop you from finding out independently whether the client does have assets located in a foreign country, and there's nothing that stops you from going to the creditors meeting and asking the client, do you have assets in a foreign country? And if they answer that question incorrectly or dishonestly, then you might have a basis for waiver of that privilege anyway. Then a sub-question under that same line, when a debtor loses their discharge under Section 727, does that also prevent discharge of future debt? No, the discharge that's denied relates to the debts that the debtor had at the time that he filed the case, and those debts are non-dischargeable forever. So in other words, if you file bankruptcy number 1 and you're denied your discharge, even if you file bankruptcy number 2, you can't discharge those debts from that predate the prior bankruptcy. But future debts wouldn't be subject to the earlier discharge anyway, because a debt that's incurred after the debtor files bankruptcy isn't subject to the discharge anyway, at least in a Chapter 7 context, where there's a bright line pre-petition, post-petition. That rule could be a little bit different in a Chapter 13, Chapter 11 context, where the line isn't so bright as to pre-petition and post-petition, because the debtor in a Chapter 13 or a Chapter 11 is kind of operating for some period of time in a bankruptcy case. Then it might depend on what happens in that bankruptcy as to whether it gets confirmed or dismissed or converted to Chapter 7 would depend on what might happen to the debt that was incurred then. One other point that I wanted to bring up that I saw from the prior discussion in part one, and particularly in light of what's happened between part one and this part with the storms that we've had, I had an interesting issue arise about insurances, and particularly business interruption insurance. Business interruption insurance is kind of a unique animal. It protects you from loss of business income or expenses that you incur as a result of something like a storm or some other event that might be insurable that interrupted your business. Business interruption insurance is a little bit different than from casualty insurance. Like, let's say you had casualty insurance that covered fire or theft of a piece of equipment. The reason I think this is really important is from a secured creditor perspective. If you're a secured creditor and you have a lien on all of the assets of a debtor, do you have a lien on business interruption insurance? I think the law is pretty clear that if you have a lien on an asset that is an insured asset, i.e. you have a lien on equipment, and that equipment gets destroyed or stolen, and then so there are insurance proceeds available, I believe that the secured creditor's lien would follow the proceeds of that equipment. What's unique about business interruption insurance is it's not really proceeds of collateral. It can arguably be proceeds of collateral, I guess, if you wanted to argue it was the proceeds of accounts receivable or contract rights, but generally business interruption insurance covers net revenues or net profits, taking expenses into consideration. And for example, business interruption insurance might cover expenses that you paid while your doors were closed. For example, you might pay payroll for several days to people that weren't actually there working because you paid them even though you didn't have power and you couldn't open your business. That's not the proceeds of any collateral. So there's a very interesting question about whether a secured creditor can get or has a lien under the Uniform Commercial Code against business interruption insurance. There's an exception in the Uniform Commercial Code that suggests that liens on insurance are not governed by Article 9 of the UCC, and that they're governed more by assignment of insurance law. And that's where it's important, if you are a secured creditor, to know that you are named as a lost payee. You wouldn't want to be in a situation where you thought, because of having a UCC filing, you were going to be entitled to business interruption insurance, only to find out that the lost payee on the policy was another creditor or another party. So just an important issue in light of these storms that we've had recently. So let's move on to part two, and what we were going to talk about, primarily pre-bankruptcy planning considerations. And one of the most important things there to always keep in mind is who or what is your client. Is it an individual? Is it a company? Which company is it? I mean, we all know we often have meetings with clients, and companies are represented by individuals, and those individuals are often have different rights than the client, the corporate client. And I think it's important in your engagement letter, particularly where you know the client is coming to you with financial issues. If you're not a bankruptcy lawyer, that might be something you don't think a lot about. As bankruptcy lawyers, we think about it a lot because there are special rules on ethical issues and conflicts about representing multiple parties, but it's very often you have a client that's an existing client, he has a problem, he walks in, he talks to you individually, and the next thing you know, you're talking about the rights of the corporation, you're talking about his individual rights, you're talking about his friendly creditor friend that loaned him some money, and maybe they didn't properly perfect their lien. So if you're the lawyer in that room, you need to give some thought to who your client is, because if you have a conversation where the debtor and the creditor of the debtor and the insider of the debtor are all in the room, it may be very difficult to claim an attorney-client privilege as to all three of those, because the general rule in bankruptcy is that once a corporation or entity files bankruptcy, it is the trustee that holds that privilege for the corporation. So, for example, if you were in the room with the corporate client and the individual client, and the corporation later goes off and files bankruptcy, then the trustee in that corporate bankruptcy comes to you and says, what was discussed at the meeting that you had with ABC Corp and Mr. ABC individually, and then you're stuck in a spot, well, wait a minute, that was a privileged communication, but you're going to have a very difficult time protecting that. So you need to be clear about who your client is and understand that if there's any prospect of bankruptcy in the future, that particularly a corporate bankruptcy, there's simply no question that the attorney-client privilege belongs to the trustee. They don't have to waive it. They don't have to waive the privilege. They just come to you and say, you previously represented this corporate debtor. I want to see your files, and you're obligated to turn those files over. So you might want to also be giving some thought as to what you put in those files in the way of notes and other things that commemorate what happened at that meeting. So the rule is a little different with respect to individual debtors. The law is not clear as to whether the attorney-client privilege in an individual case belongs to the individual bankruptcy trustee. But I still would be very careful because you could have other issues of work product that come up where you you provided opinions or whatever that maybe went to third parties, maybe they didn't. I'd be always thinking about someday if one of these parties files a bankruptcy, is this the type of information that I want to end up in the hands of a trustee who could A, sue my other client, or B, sue me? Because when your client files bankruptcy and loses control, and by that I mean in a Chapter 7 bankruptcy, obviously the client files and immediately is out of control of all of its assets, except for exempt assets, and obviously causes of action like a malpractice claim against your prior lawyer is not an exempt asset and never would be. Now in a Chapter 11, it might be a little bit different rule because your client might remain friendly, but I think you've got to assume that someday that cause of action could land in the hands of somebody who might go after you for having given bad advice. Pretty clear that that cause of action belongs to that trustee because it's property of the estate. Even in a case, and this was the case I was involved in, even in a case where the malpractice was advising the client to file the wrong kind of bankruptcy or advising the client to file bankruptcy at all, the law is clear that because that advice was given before the client filed bankruptcy, that claim belongs to the trustee because the claim arose immediately prior to the filing of the bankruptcy. So then you're going to be answering to a trustee, and what's likely going to happen is the trustee and the debtor are going to get in cahoots and turn on you because that's going to generate money to pay the debts of the debtor who's your former client. So it's always something to be thinking about. Remember, when kind of a general rule of thumb, when it's between you and other people, or it's between your former client and you, rest assured the former client is going to look out for themselves. They're not going to look out for you. So these privilege issues when dealing with clients in financial distress are something you should always be thinking about. Along those same lines, you need to be concerned about the crime fraud exception that applies to attorney-client privilege. The crime fraud exception generally and historically applied to, just like it said, crimes and frauds. In more modern times, the crime fraud exception has been applied to fraudulent transfers. For example, client comes to you and says, I want to buy a house, I want to move some money offshore, I want to do whatever. You advise them about that, and then you could be faced with a creditor or a trustee coming to you, taking the position, or creditor, very unfriendly usually, taking the position that you assisted the client in committing a fraud. I personally don't think the crime fraud exception applies as easily as others might think to a fraudulent transfer, but there certainly are cases out there that apply the crime fraud exception to a fraudulent transfer. And then depending on what jurisdiction you're in, you have other problems of aiding and abetting a fraudulent transfer. In Florida, the law has become fairly clear that there is no such thing as aiding and abetting a fraudulent transfer, but there are other states where there is such a claim, or conspiracy to commit a fraudulent transfer. There are other states, and there are other states. I know of at least one statute in Virginia that actually says that anyone out there, it could be a lawyer, an accountant, a banker, a financial advisor, anybody that participates in a fraudulent transfer can be sanctioned by the court and held accountable for damages suffered by the creditor. That's the kind of state you want to stay away from. But if you're dealing with an out-of-state client, you need to be even more careful and research what you may be up against from the standpoint of crime fraud exception or other causes of action that could come back to you. Another question that comes up in this area are what's called a joint defense agreement. Oftentimes you'll have clients like a corporation and an individual, or a corporation and another friendly client or friendly business colleague of your client, and you're defending a claim, and so you enter into what's called a joint defense agreement. So because you're both jointly defending a claim brought by a common plaintiff, and you want to be able to share information, and that's all great, I think, up until one of the parties to the joint defense agreement files bankruptcy. I don't think a debtor in bankruptcy can enter into a joint defense agreement without court approval, because that's certainly not, in my view, a transaction that would occur in the ordinary course of business. So it would need court approval, and if it was entered into prior to the bankruptcy filing, I can imagine several ways that the trustee or a creditor could challenge a pre-petition joint defense agreement. There are numerous situations where that could be problematic, and joint defense agreements themselves, I think, are problematic in the first place, but they're certainly problematic when you're talking about a client that's in financial distress that may end up in some type of bankruptcy. Another thing on privilege that you need to be aware of is that there is no there is no accountant-client privilege under federal law. There is under state law, but under the federal rules of evidence, there is no accountant-client privilege relating to a claim brought under federal law. So if you're sued by a bankruptcy trustee for a fraudulent transfer or preferential transfer under federal law, under federal bankruptcy law, and the client had spent a lot of time discussing the situation with his, her, or its accountant, those communications are not going to be privileged. I typically advise clients to not have those types of communications with anyone other than counsel. I think having accountants in the room or financial advisors or whatever you want to call them, business consultants in the room when you're talking about things that you definitely want to remain privileged, I think it's frankly foolish to have those additional people in the room. I understand they want to be in the room and the client may want them to be in the room, but it's something that you need to always be cognizant of, not just accountants, but a lot of times clients come to you and they bring their wife or their girlfriend or their husband or their boyfriend or their fiance or their next door neighbor or whoever they want to bring. If there's somebody in the room that's not the client and that's not directly involved in what's going on, that's not a privileged communication. You've waived that privileged communication, and so you kind of have to, when you're talking about pre-bankruptcy planning things that you definitely want to remain privileged, you always need to look at all the people in the room, and sometimes you don't have any choice but to kick people out of the room that simply are going to destroy the attorney-client privilege. Obviously, if the client says, I want to have them in the room, then, that's something I would document with my client, that essentially they were waiving the attorney-client privilege. On pre-bankruptcy planning stuff, that's become a difficult area of the law. There are people out there that frankly think that it's not an ethical area of the law to practice in. That's not a position that I agree with, at least in Florida, which is where I practice. But, if it's one thing to flat tell the client, this is how you can hide an asset from somebody, and tell them, here are your options, here's a homestead exemption, and here's how it works in and out of bankruptcy, here's this type of investment vehicle, whether it be an annuity or a life insurance policy or a retirement asset, and here's how it will work or not work, and give them the pros and cons of using that and whether it might be attackable or not, and let the client make that choice. That's a far cry different from just flat telling them and assisting them in hiding assets. I think one of the most important things as a lawyer that's involved in that type of advice, whether it's estate planning, asset protection planning, whatever you want to call it, is a lot of lawyers keep their fingerprints off that deal. They talk about the options and what's available, and then they have the clients go off to their normal attorneys and consummate transactions, transfer real estate, change things that need to be changed. That's probably not a bad idea, and something you should give some thought to, so that you're really covering yourself in that sense. You don't want to have creditors looking at you to be somebody that they can go after. I want to go back now, after talking about some of those pre-bankruptcy planning considerations, and go back and dig a little deeper into some of the stuff we talked about in part one, where my partner Al Gomez talked about chapter 7 and chapter 11 and chapter 13, and dig a little deeper and give you some more details on how some of that stuff works. Chapter 7 was the first chapter we talked about. I wanted to talk a little bit about the mechanics of the Chapter 7 trustee and how that works and how that person is appointed. Chapter 7 trustees are on a panel that's approved by the Office of the United States Trustee. The Office of the United States Trustee is a branch of the Department of Justice that oversees all bankruptcy cases. That's primarily what they do, and they're the ones that keep the list of eligible Chapter 7 trustees, and they're the ones that keep an eye on the trustees and make sure they're playing by the rules. Chapter 7 trustees are usually appointed by random appointment. Just whoever's name comes up next and gets drawn. While that's generally the case, I'm certain there are situations where a case is of significant importance or has some certain issues in it that I'm fairly certain that Chapter 7 trustees are sometimes picked by the Office of the United States Trustee's Office for a particular case. But there's also a mechanism in the Bankruptcy Code to elect the Chapter 7 trustee, and that can be used if by creditors, that's done at the creditors' meeting. If you're ever going to go down that path, you need to spend some time looking through the Bankruptcy Code sections to talk about election of a trustee. There's a lot of details there that do that, because if you want to have a different person be the trustee, you can get in a competitive process where people are, in certain kinds of cases, voting for trustees that they have relationships with or that they've represented in the past. A lot of times what's going on is that lawyers involved in the case want to represent the Chapter 7 trustee because they know that it's a significant case with significant litigation in it, because while most Chapter 7 trustees are lawyers or accountants, even the ones that are lawyers typically hire outside counsel if they're going to have litigation. So it is very common in a Chapter 7 case that the Chapter 7 trustee will hire the counsel of one of the bigger creditors in the case. That's oftentimes a very good idea for the Chapter 7 trustee, because it may be that creditor's attorney has been chasing that debtor for months or years prior to the filing. That's also an important thing to understand as a debtor, because a lot of people make the mistake of filing corporate bankruptcy cases, or for that matter, individual bankruptcy cases, and thinking, well, I just got rid of that creditor, and that's why I did it. Well, a lot of times you don't get rid of that creditor, because that creditor's attorney, if they're familiar with the bankruptcy process and they know the trustee, the first thing they do is they pick up the phone and they call the trustee, and they get the trustee to hire them, and so you really haven't gotten rid of that lawyer that's been chasing you for the last several months or years. You should expect that that's what's going to happen. You should expect that trustee is going to end up hiring the very lawyer that you're trying to get rid of. So filing a bankruptcy to try to get rid of the lawyer that's been making your life miserable is probably not going to work for you. Now, Chapter 7 trustees, what kind of rights do they have? In Part 1, we talked about that they have rights to bring fraudulent transfer actions and preference actions, but they also control a bunch of all the litigation that would belong to the debtor. For example, you could have any kind of litigation, a personal injury case, a malpractice case, a case for damages against anyone on the planet, and that now belongs to that Chapter 7 trustee, and that Chapter 7 trustee can now prosecute or settle that lawsuit, certainly over any objection of the debtor. The debtor in a Chapter 7 rarely has standing to object to anything that a trustee does, unless the case could be what's called a surplus case, meaning that the assets in the estate exceed all of the cost of the bankruptcy case and all of the claims in the bankruptcy case. Surplus bankruptcy cases are few and far between. I'm not going to say I've never been involved in one, but it is very rare that you find yourself in a surplus bankruptcy case. So all that means is that the debtor can't object to anything that the trustee wants to do, you could have what you thought as a debtor was a very valuable lawsuit against one of your creditors. And if that creditor's smart, he's going to go to the trustee and he's going to try to settle that lawsuit for a very small amount of money. And I can tell you I've settled lawsuits that debtors thought were worth millions of dollars. I've settled lawsuits for very small amounts of money, like $10,000 or $25,000. Lawsuits that debtors thought were worth millions. One of the more interesting kind of cases that lands in the lap of the trustee is a shareholder derivative suit. You could have a case where shareholders had brought a derivative claim against the company or against the insiders of the company. And when that bankruptcy is filed, that shareholder derivative suit then belongs to the Chapter 7 trustee. I had a case recently where my client was the target of the shareholder derivative lawsuit, and the company filed bankruptcy, and essentially what happens is that cause of action gets sold to the highest bidder. And my client offered $25,000 to settle the lawsuit, and nobody else offered any more, and what was being represented as a multi-million-dollar shareholder derivative suit got settled for $25,000. Another kind of claim that can fall into the hands of a Chapter 7 trustee are claims against directors and officers for D&O misfeasance or malfeasance, and those types of claims are often insured. I was involved in a case over the last couple of years where the debtor had was a Chapter 7 debtor. The case was filed as a Chapter 7, and but the debtor had significant D&O policy with $10 million of coverage. And once the bankruptcy was filed, a handful of creditors filed lawsuits. The bankruptcy trustee filed her own lawsuit, and all of those parties were brought in together into one big mediation, and the carrier ended up paying out $8 million of the $10 million of the D&O insurance. And an interesting power that the bankruptcy court has in connection with compromises is granting what are called bar orders. And a bar order is nothing more than an injunction that bars third parties from going after the debtor or the directors and officers or the insurance company. And so a settlement ultimately got approved where all parties, anywhere that could have any conceivable claim against any of the directors or officers or their policies, the court approved a settlement where the D&O carrier paid out $8 million, and all parties were barred from taking any further action. So that's an instance where a Chapter 7 trustee obtained some incredibly strong rights. And these rights are separate and apart from fraudulent transfer or preference cases, which are the kind of the ordinary cases that get brought by Chapter 7 trustees. One of the cases, and we talked a little bit about this in Part 1, one of the kinds of cases that are brought by trustees very commonly are preference cases. A preference is a transfer to a creditor on account of an antecedent debt, a pre-existing debt, at a time when the debtor was insolvent, that permitted that creditor to receive more than it would get in Chapter 7. So I know that was a long sentence, but let me give you an example. You're nothing more than a vendor of a company, and you ship goods to them on a fairly regular basis, and they pay you on account. Maybe those terms are 30 days, maybe they're 60 days. Maybe they're 2% 10 net 30, whatever they might be, but we all know that as customers slide into insolvency and bankruptcy, that they start slow paying. So they end up paying not within 30-day terms, but 45-day terms or 60-day terms or 90-day terms or whatever, and the kind of the terms that are on paper are not the terms that exist in the course of dealings of the debtor and your business. Those are the types of people that often get sued for every transfer within 90 days of the bankruptcy filing. That's one important thing I forgot to say when I gave the definition of a preference, but these relate generally to transfers within 90 days. So what Chapter 7 trustees do typically when they get a case, Chapter 7 trustees are looking for assets. They're looking for as many assets as they can find because, one, they want to make payments to creditors, but two, they get paid, Chapter 7 trustees get paid a percentage of the action. Okay, there's a sliding scale in the bankruptcy code where they get X percent of the first 5,000 and Y percent of the next 50,000. They ultimately get 3% of everything over $1 million. But when trustees only get paid when they have assets in their cases. If you have a no asset bankruptcy case, which the vast majority of Chapter 7 cases are, all the Chapter 7 trustee gets is a little piece of the filing fee, which is $350 or whatever the filing fee is. They change over time. But, so the trustee might get $100 for administering a no asset case. So if he has a case that's got a bunch of preferential transfers in it, he's going to want to bring them because it generates money, and then he gets paid on the percentage of all the money he disperses to creditors. So preferences are usually present in Chapter 11 corporate cases where the debtor was trying to stay afloat and slow paying people. And many of your clients, I'm sure, have received demands from trustees all over the country that say your client received the following payments during the 90 days prior to the filing. Please repay these monies. And sometimes, depending on the magnitude of your client's business with that debtor, these cases can be tens, if not hundreds of thousands of dollars. So when your client gets one of those letters,
do you have further
what are you supposed to do?
If you give me a list,
you better get it in the hands of a bankruptcy lawyer right away. You don't necessarily need a bankruptcy lawyer in the jurisdiction where the bankruptcy is pending, but keep in mind, preference cases get filed in the jurisdiction where the bankruptcy is pending. I just had a client this past year receive a letter from a bankruptcy trustee in California that they had received about $150,000 in payments in the 90 days prior to the filing, and the trustee wanted the money back. Fortunately, we were able to settle the case without hiring local counsel out in California and Los Angeles, which would have been very expensive. But the problem with preference cases is there are defenses, and I'll talk about them, but you're usually dead to rights for some amount of money. And some trustees settle them on better terms than others. Some trustees, you might be able to settle a preference case for 20, 30, 40 cents on the dollar. Other trustees might hang out at higher percentages of 50, 60, 70 cents on the dollar. A lot of that just depends on the dynamic of if you have a case with 100 preference cases that have been filed, and a bankruptcy lawyer can figure that out because all the bankruptcy pleadings are online on Pacer, and you can look and you can see that 10 or 50 or 100 or more preference cases were filed, and you can see the magnitude of all the cases. Because if you represent a trustee, a Chapter 7 trustee, the last thing you want to do is settle a case on the cheap early. So bankruptcy trustees usually try to get pretty high percentage dollars 70, 80, 90% in order to settle them pre-suit, and then they start suing people, and then you got to get a lawyer involved and defend it. So what are the defenses to a preference that your client has? If it's a contemporaneous exchange, it's not a preference, okay? If it's contemporaneous payment, in other words, you delivered goods on day one and you got paid the same day because you had the client on COD, which is what happens a lot of times when customers are becoming slow pay. If you put the client on that customer on COD, then what's happening is you're getting a $10,000 payment for $10,000 worth of goods delivered, and therefore that's a contemporaneous exchange, so it's not a preference. But the problem you've got there is a lot of times what the client does is they treat it somewhat contemporaneous. They say, look, I'll deliver you $10,000 of new stuff if you'll pay me $20,000. Well, that's not a, and then they apply the $20,000 to the old invoices. If you apply the $20,000 to the old invoices, that wasn't a contemporaneous exchange. So a client that's dealing with somebody that's in financial distress and is slow paying and is worried about preference exposure should probably talk to a bankruptcy lawyer about what they can do to minimize their preference exposure when that big Chapter 11 debtor files in New York or Delaware or California or Chicago or wherever they file, because that's where you're going to get sued. One of the other defenses to a preference is called the ordinary course of business defense, which basically says, look, if these payments were made in the ordinary course, then they're not preferential payments. Well, the problem is, as I said before, the invoice terms that you might have with that customer would be 30 days or 45 days or 60 days or less. But when you look at the payment history, you'll see that the invoice got paid in 72 days or 84 days. And so normally what happens on an ordinary course of business defense, you've got to go in and do a painstaking analysis of invoices and how they were paid, and the timing of what occurred, to make an argument that, look, while the invoice said X, our true ordinary course of business was 60 days, not 30 days. That can be successful, but it's an expensive, fact-intensive defense that will cost you tens of thousands of dollars sometimes to prove. And typically, if you're going to take a case to trial on an ordinary course of business defense, you're going to need an expert witness, because you've got to prove that that was the ordinary course of business in that specific industry. So you generally need an industry-specific expert that can help you understand what the ordinary course of business is. One of the other defenses to a preference case that you can assert is if you shipped new goods that you didn't pay for, called the new value defense. In other words, if you got a preferential payment on day one and you shipped new goods on day two, you can credit those new goods that you shipped that you didn't get paid for against your preference exposure. So those are the defenses that are generally applicable in a preference case. There can be other instances where maybe the money came from an escrowed account or something, or from a third party where there's an argument that it really wasn't a transfer of property of the debtor. But again, anytime a client gets a demand for a preference, you should get that client in the hands of a bankruptcy attorney immediately, so they can do some analysis and try to figure out what the real exposure is. A lot of times those letters have very overstated amounts in them. We've got a little bit of time left, and I'm going to talk a little bit about Chapter 11 and really just claims in general that can happen in a bankruptcy case. The first priority claim in a bankruptcy case is what's called an administrative expense. An administrative expense is a first priority claim. It's an expense. It's generally a professional fee. In a Chapter 7 trustee case, it's the fees of the Chapter 7 trustee and of the Chapter 7 trustees council. You have both Chapter 7 administrative expenses and Chapter 11 administrative expenses, and all of those get paid before the first dollar goes out to any other type of unsecured creditor. So, for example, going back to Chapter 7 that we talked about, most Chapter 7s that are corporate cases started out as Chapter 11s, and they were corporate Chapter 11s that got filed, and the vast majority of Chapter 11s end up in Chapter 7 because that sick patient does not recover. So once that case gets converted to Chapter 7, there are usually unpaid administrative expenses in the Chapter 11, attorney fees, etc. Could be rents, unpaid rents, or any other post-petition debts that were not paid during the Chapter 11. Those become Chapter 11 administrative expenses. Chapter 7 trustee then, his or her fees and the attorney fees of the Chapter 7 trustee become Chapter 7 administrative expenses that are first priority expenses. So let's say you get a Chapter 7 case that ends up with $100,000 in it, but you've got $30,000 of Chapter 7 administrative expenses and $50,000 of Chapter 11 administrative expenses. That leaves only $20,000 for other creditors. Well, then you're looking down the priority scheme in Chapter 7 of the first priority, I think, is domestic support obligations, child support, alimony, and the like. And then after that, all kinds of tax claims, IRS, etc. So again, going back to a question that was asked at the very beginning, when I get a bankruptcy notice, what should I do with it? One of the first things I try to do, and sometimes it's not easy, but you want to do a cost-benefit analysis of should I throw any money after chasing this bankrupt debtor, because you can end up doing what a lot of people do, is throw good money after bad. So if you look at a case immediately, a lot of times I immediately pull the case up and I see that there's unpaid legal expenses from the Chapter 11. I see there's a very significant landlord claim. I see that there's a very significant IRS claim, and I see that there are secured creditors, and I immediately know from looking at it that the likelihood of a general unsecured creditor getting the first dollar is very unlikely. So in a case like that, probably the only thing I'm going to do is either tell the client how to file a proof of claim, which in our district, and I think in almost all districts now, can be done electronically right off the court's website. It takes a matter of minutes to do, and file a proof of claim, and then go about my business. Write that off, file my proof of claim, and if I ever get a check in the mail years later, then good for me. But in most of those cases, you're not going to see distributions, and that's usually a pretty good thing to get a handle on early on in a case once you've got some information to look at. How much time do we have left, Alan?
10 minutes, or as much as you like.
Anybody there?
I'm sorry, I was muted. 5 or 10 minutes is fine,
okay.
Mike.
Okay, 5 or 10 minutes? All right. Well, then,
I did have one.
We talked about...
We did have one question somebody emailed, which I think is a good one. Can you briefly describe the type of bankruptcies where the trustee would own the attorney-client privilege and be able to look at the attorney-client correspondence versus the types of bankruptcy where the attorney-client privilege would be continued to be owned by the debtor?
All right, let me break it down in the 3 different chapters that we talked about in Part 1. Chapter 7, in a corporate Chapter 7 bankruptcy, there's no question that the trustee, the Chapter 7 trustee, controls the privilege. In an individual Chapter 7 case, it is not clear whether the Chapter 7 trustee controls that privilege, but rest assured, if you represented that individual Chapter 7 debtor, you may get demands made on you. In a Chapter 13 case, you're rarely going to see issues of attorney-client privilege arise. The Chapter 13 case is a little bit of a hybrid because you have a Chapter 13 trustee, but all they really do, they don't take control of assets, and they don't, all they do is make payments to creditors. They're just kind of a conduit for money that comes from the debtor to the trustee and out to the creditors on a prorated basis. So I don't think you're ever going to see an issue of attorney-client privilege arise in a Chapter 13 case. In a Chapter 11 case, where the Chapter 11 debtor is a debtor in possession and continues in control of its assets, then that Chapter 11 debtor is going to maintain the attorney-client privilege, and it's going to remain in place. But how could that attorney-client privilege get waived or impaired in some way? One, you get crossways with your client, and he decides, his bankruptcy lawyer decides that you didn't do a very good job. So if the bankruptcy lawyer makes demand on you for your file, you're going to have to turn it over. And then it may be that that bankruptcy lawyer for your former client is looking to go after you for malpractice or who knows what. The other instance is when is in the event of the appointment of what's called a Chapter 11 trustee. In Chapter 11 cases, the default rule is that the Chapter 11 debtor remains in possession and operates as a debtor in possession. But in cases of mismanagement or fraud or something, frankly, weird happening, the court can appoint a Chapter 11 trustee. And that Chapter 11 trustee in a corporate Chapter 11 case is going to control the attorney-client privilege. It does happen occasionally that you have a Chapter 11 trustee in an individual case, and again, you're going to run into the same problem of the law isn't crystal clear on whether an individual Chapter 11 trustee can waive the privilege for an individual debtor, but rest assured that Chapter 11 trustee's counsel, if you represented that individual debtor and that Chapter 11 trustee's counsel makes demand on you for your file, you have to turn it over to that trustee, I believe, because they're, I think, entitled to see it because they're standing in the shoes of your client. So that's the answer and the breakdown of where you run into a waiver of the attorney-client privilege.
Now, if there's a joint defense agreement between two different debtors because they used two different lawyers and they wanted their conversations to be privileged, can that joint defense agreement require each debtor to not waive attorney-client privilege as to the substance of those communications? Or can either debtor basically rat out the other?
I think the different debtors are going to be able to rat one another out. Unless that agreement was approved by the bankruptcy court, I'm not real excited about trying to defend a pre-petition joint defense agreement in a post-petition context. Obviously, if those two parties get at odds with one another, you're going to have a problem. If the two parties want to continue with the joint defense agreement, I would suggest that joint defense agreement get approved by the bankruptcy court, so down the road no one can try to challenge that. It may be the litigation continues throughout the bankruptcy, and the parties to the joint defense agreement want to keep it intact, and I think that can be done, but I think it should be done with court approval. But I could see as well that a joint defense agreement post-petition could be treated, depending on the terms of the agreement, as some type of executory contract, it could be rejected under an executory contract type analysis. So I think joint defense agreements are problematic where you don't have court approval.
Okay. So how does a lawyer who's doing work for a debtor or potential debtor who wants to be able to prove that that lawyer told the debtor everything the debtor needed to know about a particular strategy in writing so that the lawyer is protected to show that he told the debtor everything the debtor needs to know, but later that letter may damage the debtor if the debtor loses the privilege and the trustee comes in? So how do you balance that? How do you handle it?
Yeah, that's certainly a double-edged sword that you see, particularly when you do asset protection work. And I think, you know, there's lawyers that document their files and do like they would ordinarily do, and then there's lawyers that don't document their files at all. They don't keep notes of meetings. They don't send emails with substantive communications in them. They don't send letters. They don't send memos. And so I guess you got to decide which route you're going to take. Are you going to take the I'm going to document everything approach? Really, when you're doing that, I'm not sure you're doing that for the client's benefit. You're probably doing that for your own benefit. So I question which, you know, I don't know what the right answer to that is, but it seems to me you either need to document everything like you normally would with any other client, or you need to not document anything so that there's nothing there that could be discovered of a negative nature. The problem, as you know, when you have these asset protection type meetings with clients, they can ask all kinds of questions that you don't even expect that they're going to ask, and I think it's dangerous to have that kind of colloquy occurring in emails, for example.
Right. Okay. Now the crime fraud exception. As you and I know, there's at least one lawyer in Florida who represents creditors who thinks that advising a client relating to a transfer to avoid creditors, commonly known as a fraudulent transfer, opens up the lawyer's file for the creditor because that is the same thing as a fraud. Is that something that's been handled in the courts, or is that an open question? Because if we all had our, if we were all going to lose our files to creditors because we counseled clients as to whether to make a transfer that might avoid the creditor, that would really change the game here in Florida.
Well, certainly there are cases out there where the crime fraud exception has been applied to fraudulent transfer context. For every one of those cases, there's twice as many or more cases that say a fraudulent transfer is not equal to actual fraud. I think that law is in a state of flux. And again, I think you're caught between a rock and a hard place of how you document that and how you communicate it, because aggressive creditor lawyers are going to keep pushing and pushing and pushing. And if you're in state court, as opposed to a bankruptcy court, as we all know, bankruptcy courts tend to be more debtor-friendly, because in bankruptcy courts, that's all they deal with are debtors. In state courts, debtors don't get a very fair shake. So I think the problem we have are aggressive creditor lawyers that tee these issues up in front of state court judges that immediately jump to the crime fraud exception because there's a handful of cases out there that apply it, and the next thing you know, you're turning over your file.
Okay. The last question I had, I've read a couple of cases where, for example, the debtor had $1 million worth of assets and a $4 million debt. So the debtor then used an asset protection strategy recommended by a lawyer. The strategy didn't work. The debtor goes into bankruptcy. The creditor gets the $1 million. And then because the debtor lost the $1 million because of bad advice, the trustee in bankruptcy then sues the law firm for another $1 million on behalf of the debtor, because the cause of action for malpractice belongs to the trustee in bankruptcy. Is that possible?
Well, anything's possible. In that context, I mean, I think what you said is certainly possible. I think, those types of claims get threatened all the time. The difficulty with malpractice claims is damages. I mean, lawyers make mistakes all the time, and lawyers give bad advice all the time, or lawyers guess wrong all the time. But at the end of the day, what's
much of the
damage?
time?
I mean, I've had cases where trustees have called me and said, "Hey, Mike, the debtor's counsel pre-petition told him to transfer this asset, told him to put his homestead in the name of a limited partnership." Okay. So the debtor lost his house. So the house is now property of the estate, and the house gets sold and liquidated, and the creditors get the money. And so the debtor's counsel committed malpractice by advising the debtor to put his homestead into a limited partnership. And that certainly was malpractice, but again, what were the damages? If the estate got the money anyway, you can't get a double recovery. So I think the problem is what are the damages that flow from that malpractice? And I think in that instance, you don't have any damages.
Okay. Okay, very good. Well, Mike, I'm sorry that I chewed up all your time. Is there anything else you want to say before we sign off? I know you need another hour, which we're going to have.
Yeah, well, we'll go into some of the more detailed Chapter 11 stuff when we come back for Part 3.
Okay, well, thanks so much. It's greatly appreciated. Thanks to everybody for attending today's webinar, and may the rest of your time be billable.